Welcome to the second webinar in our series of webinars about user recruitment. This webinar will look at what we've learnt in the last 6 months since GDPR came into place. Our guest today is Ed Boll, who is a technology and data protection lawyer at Greg Blatchams. So there's a couple of reasons we decided to do this webinar on this subject, partly because it's been 6 months, the dust has settled, and it's a good time to reflect on the changes that we've implemented at the start of the year. Also, the UX sector is evolving all the time, with more companies setting up research teams every day. This means working out how to apply the legislation or internal policies to make sure that you're not only working in line with the law, but also that you're putting users at the centre of your research process can be a challenge. I need to be on the right window. So rough overview of what we're going to cover today. Ed's going to start with an introduction to the General Data Protection Regulation for anyone that perhaps is unaware. It's part of UK data protection law at the moment. Then Ed's going to go through some of the key elements of the legislation which relate to user recruitment. And I'm going to provide context for each of those key elements that we've picked out by describing a situation from our experience in which, from a user recruitment or research perspective. We've also got a Q&A section at the end, which will hopefully be around 15 to 20 minutes. So if you do have any questions, please feel free to fire those across at any point just through the GoToWebinar window. And I suppose just a reminder that we specialise, so People for Research specialise in recruiting people for research. Therefore, most of the information that we'll be providing will be from that perspective and considering what's best for the users throughout that process. We're not aiming to provide legal counsel. And the areas that we've picked out that we're going to talk about really based on the most common queries that we've had over the last year, both in the lead up to the 25th of May and since, but it will be really interesting to see what other questions people have for either myself or Ed. So I'm going to, at this point, hand over to our guest and expert.
Great, thank you very much, Jess, and thank you very much for inviting me to join the webinar. I'm sure that the GDPR won't have passed you by. If it has, then you have had a very long and deep sleep for the past 6 months. I'm just going to run through some brief headlines about the GDPR. A lot of this may be familiar to you, and if you've heard it before, then I apologise. But I'm assuming that those on the webinar perhaps don't know these things. So just to jump in, the GDPR is the most significant upgrade to EU data protection law since 1995, when, believe it or not, Facebook and Google didn't even exist. And in the past 20 years, we've seen significant social, political, and technological impacts that these massive platforms have had. And so the GDPR, which has taken over 4 years to negotiate between the 28 member states of the European Union, was really viewed as an absolute necessity in that context. It aims to create a level playing field by harmonising data protection law across all of the EU member states. Previously, we had a hodgepodge of different data protection laws in different countries, and as a business trading with the EU, that made it very difficult to know with which laws you should be complying. It came into force on the 25th of May 2018, so we're 6 months in. The fundamentals of the GDPR are the same. As the Information Commissioner Elizabeth Denham likes to say, the GDPR is an evolution in data protection law, not a revolution. But for those organisations who hadn't really engaged with the previous law, the Data Protection Act 1998, the GDPR was very much a shock to the system. And the first question I would generally ask clients when they picked up the phone asking for advice on GDPR was, well, to what extent do you comply with the Data Protection Act 1998? And when there was silence on the line for more than a minute, I had my answer. The GDPR sets out 6 key principles which are fundamentally the same as the principles under the 1998 Act, with an overarching accountability principle which is a sort of silver thread that flows throughout the entirety of the GDPR. And what that essentially requires is that it's not just enough to comply with the key principles of the GDPR, you have to be able to demonstrate how you've complied with those key principles. And what that really means is showing your workings. So any decisions that you make about how the research is going to be structured, how you're going to engage with the participants, how long you're going to keep the data for, where it's going to be stored, all of those things ought to be documented so that you can support any inquiries that the ICO might raise at a later date. If you're going to be collecting and using personal data which represents a high risk to the individuals that you're collecting it about, then you have to undertake something called a data protection impact assessment. In the context of research, you might want to consider that where you are going to be processing personal data of a particularly sensitive nature. So if you're asking questions that might reveal somebody's health condition, sexual orientation, religious or philosophical beliefs, those types of things are going to require that assessment to be undertaken beforehand. And the objective of that exercise is to identify what the risks are and consider how you're going to mitigate or, if possible, eliminate those risks. The other important thing that the GDPR does is it subtly enhances some of the existing rights that individuals have under the previous law, such as the right to obtain a copy of your personal data, which is popularly known as the subject access right. And it also introduces a few new rights, such as the right to ask an organization to restrict how they're handling your personal data, the right to request that they delete it in certain circumstances, and the right to ask for a copy of that data in a format that they can take away and give it to another supplier without having to provide it all over again. Some of those rights are, like the right to data portability, probably not hugely relevant in the research context. And then finally, yes, of course, those fines that were much hyped, slapped across the headlines of a lot of newspapers and fairly reputable publications online who were pretty much predicting Armageddon by the ICO come the 25th of May. On the 25th of May, I took the day off and went to the spa. The next day was a Saturday, and on the Monday, the world still hadn't fallen apart, much to everybody's relief. So in terms of what we have learned since the 25th of May, we've seen clients come back to us with things that they did in a rush to put something in place by the 25th of May, and now they're able to relax. Now they realize that the regulator isn't going to be banging down their door, and they can go back to what they've done previously and do it properly and make sure that they've really thought it through, which is very important. A number of our clients, particularly in sectors such as professional and financial services and consumer services, have seen an increase in the number and complexity of requests that are being made by individuals. And of course, the ICO has been absolutely inundated with requests and complaints and inquiries and reports of data breaches, over a 200% increase. Whether or not some of those data breaches actually needed to be reported under the GDPR is a subject for another day. But the ICO is a regulator that is typically quite conservative, and I think it would admit it's massively overstretched. And although certain measures have been taken to try and alleviate the burden on the ICO, it still takes anywhere up to 3 months before the ICO can assign a caseworker to a particular complaint. So it's not an excuse, it's not a justification for relaxing, but it's just a fact that they are massively overstretched. The first enforcement action taken by the ICO went under the radar. They issued something called an enforcement notice against a Canadian company called Aggregate IQ to basically ask them to stop processing personal data relating to UK citizens. That company was involved in the Cambridge Analytica inquiry, something which has also been a massive distraction for the ICO from properly and effectively enforcing the GDPR, some might say. And the biggest fines that we have seen since the 25th of May were for £500,000 against Equifax and Facebook and £400,000 against Dixon's Carphone, none of which were made under the GDPR. They all related to complaints that the ICO received before the GDPR came into force. So the maximum the ICO could fine under the old law was £500,000, and that's why we haven't seen any fines in excess of those limits since the 25th of May. So I think overall, since the 25th of May, we've had the benefit of experience as to how individuals regard this law and what it means to them and how they want to exercise their rights. But we've also seen organisations taking stock and revisiting some of the rush jobs that they implemented before the 25th of May and looking at doing things properly.
Great, thank you. That was a good intro, and some things that I hadn't sort of considered that have impacted how companies and the ICO have been reacting since the 25th of May. So the first element that we're picking out is consent. So from a GDPR and legal perspective, do you want to give us an introduction?
Sure. So if you want to process personal data for any purposes in any context, you need to satisfy one of 6 legal grounds for doing so. In the context of user research, there are probably 2 that jump off the page to me, and that is the legitimate interests and also consent. You can rely on legitimate interests where you are processing somebody's personal data and where that processing is necessary to achieve the legitimate interests of you, or if you're a user, if you're a recruiter recruiting individuals on behalf of a client, the legitimate interests of the client. But before you rely on that ground, you have to undertake a careful assessment, and you have to balance up whether you or your client's legitimate interests equate with the fundamental rights and interests that the affected individuals have. And if the balance, if you can't find that equilibrium, then you shouldn't be relying on legitimate interests as the lawful basis for processing. That careful assessment can be done through something called a legitimate interest assessment. There's guidance about it on the ICO's website. They even provide a template that you can use to do that. The one thing just to be wary of in doing these types of things is that if you really want to rely on legitimate interests, then it'll be no surprise that you'll find the outcome of your LIA will be it's all okay and you can proceed. So it's always a good idea to try and get an external and sort of unbiased view on whether that is a fair assessment. Consent is very much the ground that everybody tends to gravitate towards, and that can be a bit of a mistake. It's always sort of perceived as the gold standard, because nothing can be more unequivocal than somebody saying, yes, I want to do that and take part in that research. But the definition of consent under the GDPR arguably sets the bar much higher than it did under the Data Protection Act 1998. Consent can't be fuzzy, it can't be implied. It has to be a clear, concise and unambiguous indication of somebody's wishes. It has to be specific in relation to the purposes that you want to collect it for. So you can't ask somebody to consent to give you their personal data for one purpose and then decide that you want to reuse it for another purpose, unless you can demonstrate that the two are compatible, and therefore it's not necessary to go and renew that consent. And the important point is that it has to be as easy for individuals to withdraw their consent as it was to give, which is all about giving individuals a genuine choice. The other point about consent is that it doesn't last forever, it has a shelf life. So if somebody has consented to participate in research today, that doesn't mean you can rely on that consent tomorrow, unless it was clear at the outset that you might approach them to participate in future research initiatives. If you can justify what you're doing in the context of user research on the basis of legitimate interests, then it does provide you with greater flexibility. But if you do want to offer participants a free and genuine choice and control over what you're doing with their personal data, then consent it would be the way to go. The other point to note with both legitimate interests and consent is that if somebody withdraws their consent, then they have the right to request the erasure of their personal data, which is otherwise known as the right to be forgotten. Similarly, if you're relying on legitimate interests and the participant doesn't agree that your interests are legitimate, or they agree that you do have a legitimate interest, but they consider that their rights aren't balanced against that, then they may also be able to exercise the right to erase their personal data. So there are upsides and downsides with both of those options, but those are probably the most likely options.
So from a research and recruitment perspective, as I've mentioned, it's an evolution, not a revolution. And even before GDPR was on the horizon, anyone conducting research should have been getting informed consent from the participant before getting that person involved in research. So for anyone that's not running research, informed consent means allowing people the chance to consent to participating based on a clear understanding of what's involved and the possible consequences. There are quite a few different definitions depending on the context in which you're researching. I'm sure the definition, if you're conducting medical research, is a little bit more detailed and specific. But from a sort of looking at it in very simple terms, there are two things really to consider: is why you are getting the consent and when you are getting the consent. So why, from a research perspective, is making sure that you're following appropriate research guidelines, really, that you're giving the person information on what will happen in the session and ideally the purpose of the research, so they can make an informed decision and give their informed consent about whether they want to be involved and contribute to that research. And then from a data protection point of view, the why is about letting the person know what type of data you might be asking for and what will happen to it. Both of those whys might impact whether someone is comfortable in participating. Therefore, in our sort of process, it's important to gain informed consent at the point at which you're inviting someone to participate, not once the person is in the room and about to begin the session, because then it might be potentially difficult for that person to withdraw their consent, because they might feel the pressure of, well, I'm sitting here and I'm wasting your time.
Even if they give their consent, is it freely given in that context? If they're already there, they might feel awkward about withdrawing it. So
yeah,
that consent would probably be invalid anyway.
Absolutely. So in our view, it's about changing the existing processes, adapting it. Hopefully you were getting informed consent earlier on in the process anyway. You need to make sure that any language used is easy to understand. And if you do have quite a complex consent form, which some organisations we work with do, our advice is to send that to the participant ahead of the research, so they have a chance to review and withdraw consent before they turn up at your offices. So just looking at the key points I've picked out is tell your recruiter, if you're using a recruiter, what's happening in the research session. Avoid asking the participant, I'm skipping ahead. Yeah, brilliant. I've covered everything on that side. So just to give a bit of an example around this, hopefully to make it clear there's advice that we're giving really, is a client of ours was running usability testing on an online form. During the research, they asked participants to complete the form using their own information. The participant happily complied, but didn't actually realise the form was live and that part of that process meant signing up to a live service. So if you're using a recruiter, it's really important to provide accurate information about what you're planning to do in the research. Our advice, where possible, is to avoid asking the participant to use their own personal data, so there's never going to be any confusion around what's going to happen, or if you're not collecting personal data, it means you don't have to worry about how you're processing it and storing it and all those things. The request for informed consent should be tailored and then relate to what's actually going to happen, rather than just using the same informed consent for any type of research you might be conducting. Be transparent, and the last one is perhaps a bit more difficult, but don't make assumptions. So I think in the situation I described, from the client's perspective, it was clear that this was a live service, but from the participant's perspective, it wasn't. That wasn't clear, hence why afterwards they were a bit confused. So moving on to the second element, data management. So again, Ed, if you want to kick off.
Yeah, sure. So I mentioned that that accountability is a central concept to the GDPR. So too is transparency. Um, as a general rule of thumb, I always say if a client would be surprised by what you're doing with their personal data, something's gone terribly wrong. And it's likely because you've either not been transparent with them or you've not clearly communicated what they're doing with their data. If that's the case, you may have a bigger problem, which is that if somebody doesn't understand what you're doing with their personal data and why, that processing will not be fair and it will probably not be lawful. And if that isn't the case, then that's one of the fundamental principles of the GDPR that you have breached. You have to explain, as you were saying, in clear and plain language, what you're going to collect, what you're going to do with it, what legal basis you're relying on, who you're going to share it with, how long you're going to keep it for, who's going to have access to it, is it going to be transferred outside the EEA? And that information is typically provided in a privacy policy or fair processing notice. And as you said, it's really important that that's tailored. It doesn't have to be written in legal language. It should absolutely not be written in legal language. I'm not a big fan of privacy notices that cite sections of the GDPR or any legislation for that matter. It doesn't help. And then the other point in relation to data management is to have a think about anonymization and pseudonymization. Pseudonymization is one of those things that people find, including myself, stumble over and find really difficult to say. Anonymization is where you strip a data set of all of the identifiers that could link it to an individual. And once you've done that, and once it's practically impossible to reassociate that data with the individual that you collected it from, it's anonymous, and the GDPR doesn't apply to anonymized data. So you can do with it what you please at that point. The important point to note is that up until the point when you anonymize the personal data, you still have to comply with the GDPR. So anonymization isn't a kind of a get out of jail free card in terms of complying with the GDPR up to that point. Pseudonymization isn't even really a halfway house to anonymization, and some people think it is. Pseudonymization is where you essentially split the data set. So on the one hand, in one location, you have the identifiable attributes, and in another location, in another data set, you have the non-identifiable attributes, the attributes that do not represent somebody's personal data. And essentially that's a security measure, because if you lose the one half of the data set, then it's not possible to re-identify it with the other. If you lose the half of the data set that includes the personal data, yes, it's still a personal data breach, but the risk associated with that loss or compromise might not be as significant. The important point to note is that pseudonymized personal data is still personal data, so you have to comply with the GDPR in full. Now, if you collect personal data relating to participants and share it with a client, if you're a recruiter and you share it with a client in a pseudonymous form, then it will be pseudonymized for you, the recruiter, in the hands of the client, unless they have some right to get you to give the names of the individuals. It will be anonymous in their hands. So in their hands, they can do with it as they please. And that could be quite convenient for a lot of clients and something worth thinking about. If there isn't really any value in knowing the identity of the individual who participated in the research, it's generally going to be better that you don't, unless you have some additional purpose, which is that you want to be able to follow up with them one-on-one or invite them to participate in further research. So those are just sort of some key takeaways in terms of how the GDPR impacts how you manage data in the research context.
Oops, I've clicked on the button again. So again, trying to apply that to what we do and user research. In my experience, since looking at all of this, I've realised it's impossible to run research or do any kind of recruitment without generating a lot of data and duplicating that data by sharing information with stakeholders involved. At the same time, one of the key principles of the GDPR is that you do not ask for more personal data than you really need, for example, to fulfill the research objectives. As part of that informed consent that you gain, You'll need to let participants know what their data is being used for, how long it will be stored for. So you need to be confident that that's something that you can abide by. So again, you almost need to think ahead about, okay, how am I going to be presenting the research findings back? Who will I be sharing it with? For example, is it going to be at a national conference with everyone that works for the business, or is it just for an internal, within your team, just to reflect back on the session, take some notes afterwards, and that's all you're using a recording for? So one of the practical things that I would recommend is taking a look back at a workshop that some people may have heard of, ran by someone called Kate Towsey, who used to work for GDS and BBC. I went to the workshop that she ran at UX Bristol, but I know that she ran this workshop at a couple of other conferences across the UK this year. There's a link on the bottom of this slide to a bit of information. Unfortunately, I've not managed to find any other information or any kind of video of the workshop anywhere else, but it gives an introduction into her objectives. And it's essentially where you map out all the different things that you might collect during the research process, from consent forms through to photographs of the people who participate, and all the different places that you might put that. For example, with the photograph, you may take that photograph on your phone, then you'll transfer it to somewhere else to save it, maybe on a computer, then you might upload it into a shared drive for the client, and you need to then know that you can map that back and delete all of those places that photo is. And this will also help you to understand who else might need access to the different elements of the data, how you're going to keep track of it and maintain that security. And of course, when it comes to actually deleting the data, so if someone exercises their right to erasure, that you've got those things in place, so you can go, okay, I feel confident that I can do that and won't miss anything.
Sure. Yeah, I mean, data mapping is a really important exercise, and you can't even begin to explain to participants what you're collecting and why you're collecting it if you haven't done that initial step. So with absolutely any initiative, even outside the context of user research, it might seem like a bit of a drag when you just want to get on with it, but it does mitigate the risk of you doing things like collecting more personal data than you need and sharing it indiscriminately with people that you shouldn't. It really sort of focuses the mind and gets you to think about things in more detail.
So an example of some changes that we've made since GDPR came into force. So there's two things that we did, which, where possible, when sharing participant information with clients, we anonymise or pseudonymise it, and remove all personally identifiable information. So if we don't need to share personally identifiable information, it's a bit of a tongue twister.
It is. Personal data is probably easier.
Personal data, yeah. So if we do need to share that, we make sure that we gain explicit consent from the participant when we're going through that recruitment process, and we're getting informed consent, so that, again, they can take that into account when they're deciding whether they want to be involved. And actually, this was quite an easy transition, as most clients, when asked, realise that they don't actually need a great deal of personal information in order to run their research, especially if it's sort of just usability testing. So really, if you sort of think about it, you can really reduce the amount of data you need to capture and keep. In some instances, that's not relevant, but again, if you're being transparent and asking explicit consent, as long as people understand the purpose, in our experience, again, since May, and asking these questions, most people are quite happy as long as they understand why.
And I suppose if somebody does question the relevance of a particular question, they can just refuse to answer it, and you know, that's what freedom of choice is about.
Absolutely, yeah, no, that's a good point. So the second change that we've made is we've migrated to SharePoint to manage all recruitment documents, and this allows us to revoke access, put expiration dates on documents, and just gives us a slightly different element of control. Tools like that are great for collaboration and can help make processes more efficient, whilst also reducing risk, which is something that you keep referring to. And our clients have, well, from the feedback that we've got, found that they've been positive changes. So the third and final element that we picked out before we move on to the Q&A is controller versus processor.
Yes, so again, this is something that hasn't really changed under the GDPR, but one of the major shifts under the GDPR is that processors, that's organizations that process personal data on behalf of another organization, can no longer use a controller as a sort of human shield in the event that there's any breach of data protection law. Processors are now subject to direct obligations, and controllers and processors have to enter into agreements that contain some fairly important terms about who is responsible for what. Determining who is a controller and who is a processor can be quite difficult, and there is really a sort of a spectrum of control. So at one end of the spectrum you have absolute control, and at the other end of the spectrum you have no control whatsoever. And at the complete control end of the spectrum, somebody will be sitting squarely in the controller camp, and at the no control at all end of the spectrum, somebody will be sitting in the processor camp. But in modern business, things are never quite that clear cut. And in the context of user research, you might have a recruiter who's helping you to determine the appropriate cohort for participation, sourcing the cohort, setting up the consents, running the research, deciding what the research should look like, how it should be structured, deciding what the output should be, and how that should be collated and presented. All of those things gradually bring an organization that might otherwise sit at the no control end of the spectrum gradually further towards their client. And where that's the case, you can create something called a joint controller relationship, where both parties are considered to be ultimately responsible for the processing of somebody's personal data for that specific project. And separately, you could have a situation where the recruiter is taking charge completely for the recruitment process. And once the data is in the hands of the client is then responsible for deciding what they do with it, in which case both parties would be considered as separate controllers, even though it's the same set of personal data. It is important because the obligations and the liabilities of controllers and processors differ under the GDPR. So it's really important that the parties really give proper thought, because it's so tempting to just say, well, we're running this on your behalf, and it's pretty clear that that's the case. We wouldn't be doing this otherwise. And we're obviously a processor, with this idea that kind of gets you off the hook for a lot of things. So it's really important to look at responsibilities and actions and rules and decision making, ultimately control and decision making, and decide which rule best fits. I suppose the important point to note is you can say whatever you want in the contract, but it really doesn't matter. So if an individual, a data subject, makes a complaint, and the ICO decides that somebody who said in a contract they were a processor is actually a controller, the ICO will have no difficulty whatsoever making that determination. So whatever you agree in a contract between a client and a recruiter is never definitive anyway, but it is worth getting it right.
Okay. So I suppose then thinking about how you might define your role, there are many different ways of recruiting people to take part in your research. Obviously, the best one is using a recruiter, ideally people for research. But it's important to know in each instance whether you're using an external recruiter, whether you're contacting your own customers directly, whether you're running guerrilla research out in the street. These questions I've just highlighted on the slide here are questions which may be a good starting point to help you identify if you're the controller or processor. So if you're recruiting yourself, then your organisation data protection policies should give you guidance on what your responsibilities are in either instance. If you're using an external recruiter, then it's important to be clear on who has what responsibilities, and just having an open discussion about protecting participant data. Like I said earlier, we had that conversation with the client about this is the information that we will share. Is this okay? We won't be sharing personal data with you unless you really need it for the purposes of the research, and invariably most of the time they don't need it. So yeah, who's responsible? The method that you're using to source people. I think, Ed, when we were having a discussion before, you made an interesting point about if you're using various platforms, to recruit people, the data protection policy of that platform? Just because someone's data exists on there doesn't mean you can.
Yeah, so you have to be slightly selective about which platforms you use, because there's without getting too technical about it, there's a case that's making its way through the European courts at the moment, which basically said that if, for example, you decide to use Facebook to run your corporate fan page, then even though you're not responsible and don't have any control over how Facebook collects personal data, you've nonetheless decided that Facebook is the platform you want to use to fulfill one of your business objectives. Therefore, you're a joint controller with Facebook and jointly responsible for that processing. And the same there arguably applies to any other platform. So if you're relying on cloud-based solutions for surveys or for video or for analytics or whatever it might be, you have to have a reasonable degree of confidence that the platform you're using shares the same respect for individual rights that with you. Otherwise, it kind of undermines all of the good work that you've done to get to that point. And yeah, a lot of these websites you'll find have trust and security pages where they explain how they respect the rights of individuals and how they comply with the GDPR. Whether or not you trust that is another matter. I'm a huge skeptic about most things, but it is worth doing your research as well.
To give an example to this particular element, the obvious one in my view that I think helps to explain how this might work is, or where there might be confusion as well as to who's the controller or the processor, is if you want an external company, for example, People for Research, to support you with recruiting your customers. So if you're providing an external company with a list of customers you've chosen and the questions you want to ask of them, and the external company coordinates that process and just collates the results, then the external company will just be a processor. If, however, you commission the external company to select the participants, structure and administer the survey, then the external company will be a controller. So it just goes back to what you were saying before about how much control people have over that process. Yeah. Historically, companies, in my experience, would recruit people based on existing opt-ins for marketing purposes, and this just isn't good enough under current legislation. So if there's any uncertainty about whether the existing opt-ins include participation in user research, I would normally advise starting that process again, just to make sure that you're being transparent.
I mean, the reality is it wasn't acceptable under the old legislation.
Okay.
But the GDPR and these big scary fines, as unrealistic as they might be, have focused everybody's minds. But yes, I mean, if you're going to ask somebody to consent to marketing specific products and services, a survey isn't marketing; it's an extension of your business activities. And if you didn't establish that is a potential purpose for processing the data at the outset, you can't quite. You know, it would be a contortion, let's say, of that consent to kind of use that as the basis to contact participants.
Well, I suppose as well, maybe certain practices and habits that have been formed come from previously. It would be the marketing department who would maybe be running some form of market research, and therefore that's why it might have been deemed acceptable to use those opt-ins, whereas now in businesses, UX teams and user research teams are quite separate to the marketing teams from the experience that I've had, and therefore that's why it's important to understand that the opt-ins aren't always reliable, and most people as well don't actually understand what user research is. They don't know what UX is. Obviously that's changing, more and more people are becoming aware. But it does mean then if you send out an email about user research, people might make certain assumptions about what that means.
It's also created some interesting debates between lawyers and legal teams and their marketing departments, who have typically sort of operated entirely independently of each other. The marketeers definitely don't want to speak to the lawyers, and the lawyers don't really understand what the marketeers do. And if you could be a fly on the wall of some of the meetings that I've had with lawyers and marketeers in the room, you would have a good laugh. Suffice to say that the objectives of marketeers aren't always aligned with the objectives of lawyers. And most of the people that I speak to in marketing say, look, fundamentally, I want to market the product or service in the most effective way I can. And if I can do that in a legally compliant way, great. Whereas the lawyer's view is legal by default, get it right, and everything else is kind of icing on the cake.
So going back to controller versus processor, to give a bit of insight, I suppose, into how we would manage that process. So if people for research are tasked with recruiting customers from a customer list, we typically would determine the means of processing by asking a customer to share their details directly with us through a clear opt-in process, making it very explicit. If that process is done well, then your customer base is invested in what you're doing, obviously, then it will still generate good responses and should still result in a really smooth recruitment process, not just for the recruiter and the research team, but also for the customers, that they understand at each point in that process what they're agreeing to be involved with. And I think from the discussion that we had, that in that instance, we would be joint controllers, and we have an agreement that we would put in place with our clients to set out responsibilities of each party in that process. I suppose the last point to raise, which is something that, again, it's probably something that we didn't necessarily foresee back in May when we were sort of setting up these processes, but actually we've had a couple of instances where if we've been managing client data, we might have someone that opts out partway through that process, or decides actually it's not something I'm interested in, don't want to be involved. Can you also make sure that I don't get contacted about this again? What we found is that then at the client side, they don't always know who to go to make sure that opt-out is processed. So again, thinking about that at the start of the process, that you know, okay, what are the potential things that might come out of this, and do I know who to go to internally to make sure that we're following through all of the processes we need to follow through. Okay, so we've got 20 minutes left. It's time to move on to some questions. So we do have a couple of, yeah, this is the moment of truth. So we've got a couple of questions that we got sent through from clients ahead of the webinar. If anyone has questions as well that you haven't put through, please do send it across. So let me just look at the one that we've got here. So if the participant exercises their right of erasure, does that mean that we have to delete all of their responses?
Well, the answer to that is quite simply yes. So if the basis on which you were processing their data was their consent, and they've withdrawn that consent, then the right to erasure is engaged. And if they exercise that right, then you do have to delete their data. If that data was rendered anonymous, then you can still use the data set that is anonymized, because the GDPR doesn't apply to that, but anything else that identifies them would have to be deleted. Similarly, if somebody objects to contests your legitimate interest for processing their personal data, and you can't demonstrate that you have compelling interest that override that, then similarly they have the right to erasure, and you would have to honor that request as well.
Okay. How do you decide on how long is the right amount of time to store data, especially if your project length is not always clear with a client? That's a good one.
Yeah, so in terms of providing fair processing information to participants, the GDPR requires that you explain how long you're going to hold the personal data for, or if you can't nail it down to a specific period of time, how that period is going to be determined. At the same time, you can't have an open-ended retention period. That completely defeats the purpose and the objective. There aren't any hard and fast rules around this. The objective should be to hold the personal data for the shortest period of time possible, because one of the fundamental principles is that you don't hold personal data longer than is necessary for the purpose that you collected it for. There are other benefits as well. The more personal data that you have hanging around, the greater the risk to the organization of retaining that data, the greater the risk that it becomes inaccurate and irrelevant. So you should be striving to keep that period to an absolute minimum. If you subscribe to, and I'm going to get the number wrong, I'm sure, but ISO 20252, which is a market research standard, it suggests a retention period of 1 year from the date that the data has been collected. So you might want to use that as a sort of as a rule of thumb. But if you want to be able to revisit the responses that were given in the future to see if attitudes have changed, then you may be able to justify a longer retention period. but you can't decide that you want to extend it after you have collected it. You really need to have defined what that looks like from the outset and communicated that to the participants.
And so you've said perhaps a year is a good benchmark because of the ISO, but and I know this is almost like saying how long is a piece of string,
yeah.
but in your opinion, is a year part of that sort of short-term time frame?
Yeah, I mean,
or is that quite a long time frame?
You know, if somebody is going to be hauled over the hot coals for having stored it longer than necessary, I think in reality we're talking years.
Right. Okay.
If we're talking 6 months, 12 months, 18 months, even 2 years, I would hesitate to say it, but you know, I don't think that's extraneous in the context of the data that we're talking about. But clearly, the shorter the period that you can reduce that, the better. And you were saying that people for research will generally dispose of any personal data that it no longer needs to hold as quickly as possible. And I think that's the attitude you have to take.
Yeah. Sort of being really ruthless with yourself and going, do we really need it?
Yeah, it's not the same as, you know, hoarding things at home. You can't be a data hoarder. You have to be very dispassionate when it comes to personal data and willing to can it as soon as you possibly are able to.
So the next question I've got here is, so are consent forms, which typically gather first name, surname and a signature, considered as PII, personally identifiable information? And should these be deleted along with other PII, e.g. user videos after research is closed?
So it's definitely personal data. So anything that can directly or indirectly identify an individual is their personal data. The personal data recorded on the consent form will be personal data. You shouldn't keep it longer than necessary. If somebody exercises their right to erasure and they're able to do that, you would have to delete that content. Subject to certain exceptions, but you would have to delete that content. If once you've got their consent, you then operate the research in such a way that the data is anonymized, or you anonymize the data after you've collected it, then, as I said before, the GDPR doesn't apply to anonymous data. Therefore, the right to erasure doesn't extend to that data. But certainly, yes, the personal data contained in a consent form and obtained during the research is all within the scope of the GDPR and the rights that individuals have.
Okay, and so potentially a business could be in a situation where you've got a certain length of time that you decide to keep the videos from user research, and then you might also have a different period of time that you keep the consent forms.
Yeah, so
different types of data.
Yeah, potentially. I mean, whether you would separate it in that way, you know, it very much depends. But you know, fundamentally, it comes down to the question of likelihood of that right being enforced, those rights being enforced, and you're likely to reduce the likelihood of those rights being enforced if you have been fair and reasonable and quite basically you respect the individual. So those types of rights are likely to be exercised in circumstances where somebody feels aggrieved by what you've done or how you've set about using their data. Yeah, so it's as long as you're being respectful, you know, you should be mitigating the risk of that happening.
Okay. So the next question is if a participant says that they don't want to take part anymore, can we rely on legitimate interest?
The short answer is well, the technical answer is the GDPR does say that there are circumstances where you can rely on another ground for processing, but no, the answer is no, because the whole objective of consent is to give somebody control and a genuine free choice over what you're doing with their personal data. If they have, and they don't have to give a reason, if they've withdrawn that consent, then it's clearly unfair to rely on another legal basis such as legitimate interests for doing that. So you shouldn't do it. In any case, unless you actually did a legitimate interest assessment beforehand with a view to falling back on that if consent is withdrawn, then you wouldn't really have much of a leg to stand on if it was ever challenged. But I think if you go for consent, you have to respect that consent, and if it's withdrawn, that's it.
Okay. How long can I keep research data for? We've kind of answered that one really with those other two questions.
As short as possible.
So this question, I don't know whether this is just going back maybe over some of the things that we said, but the question's about what are the differences when dealing with anonymised versus pseudonymised data. So I'm not sure whether that's more of a practical question, possibly about.
Yeah, so anonymization isn't as easy as people think. The objective of anonymization is to make it as impossible, to make it practically impossible to re-identify the individuals with the data that you've collected. Sometimes just deleting a couple of columns off an Excel spreadsheet won't cut it. You have to look at whether you have any other data in your possession which could reasonably be used to re-identify the individual if it's combined and matched with that data. But assuming that anonymization can be straightforward, once you've anonymized it, it falls outside the scope of the GDPR. It's no longer personal data. Pseudonymization is more of a security measure more than anything, and there are various benefits under the GDPR from implementing pseudonymization. It's given as an example of a security measure that data controllers can implement to protect personal data from being subject to any breaches. So that's really the distinction between the two. One is really a security measure, and one is aimed at entirely taking the data outside the scope of regulation.
Okay. So the person asking about consent forms and whether the PII should be treated the same way as other PII has asked for, could you clarify what counts as PII in the context of user research? For example, are first names only, no surname, considered PII?
So I suppose the first point to note is that personally identifiable information is very much a sort of an American expression, and we tend to use it because we think that if you refer to information rather than data, it takes the edge off things. It makes it seem it will make people feel more comfortable with what you're doing. The proper legal term is personal data, and personal data is any data which directly or indirectly identifies somebody. So a unique identifier like your national insurance number, your driver license number, your passport number, that data can be used to identify you when it's combined with other data. If you just have somebody's surname and you don't have any other means to identify that specific individual, then it's just a name and it wouldn't be personal data. But in reality, it's likely that you're going to have other data that you can associate with that attribute and identify the individual.
Okay, so the next question is again asking for more clarity, and I think it raises a really relevant point, is isn't it risky to get rid of data consent forms? So that is usually the proof that you got the user's consent in the first place. I'll just carry on with the question, but there's maybe two questions here in one. So what if the consent is the only non-anonymous piece of information and there is no way to relate the name of the participant, so the name on the consent form, to any other data collected?
Sure.
Does this make it safe to keep the consent?
So you would want to retain the record of consent. It's you know, if somebody disputes the basis, disputes that they ever gave their consent, you do want to be able to point to something that supports your claim that they gave it. But you have to treat that consent form as a record on its own, and you have to consider the retention period for that on its own. Now, if they wanted to assert that there has been some breach of contract, then you might want to retain that form for up to 6 years from the date that they signed it, because that's the period within which you can bring a claim for breach of contract under English law. For personal data breaches, it's an interesting question because there isn't a limitation period for breaches of data protection law. So somebody could make a complaint about how you process their personal data at any point. At the same time, you shouldn't be keeping it for longer than you need. If you're given notice of a legal claim, or you suspect that a participant is going to make a claim, then that clearly justifies the argument for retaining it longer until you know whether you're out of the woods. But I couldn't generally put any period of time on it. I suppose the other thing to consider as well is that the risk of that consent record in and of itself is pretty low. So if that data got into the wrong hands, then the risk and impact to the individual is minimal. So on that basis, you know, you may consider that 3 to 5 years isn't an unreasonable period of time to keep that. If it's not possible to identify the person who gave the consent with the data that you've collected, then you look at those separately. So if the data that you've collected genuinely cannot be re-identified with the individual who gave consent, then that data will be anonymous, and therefore the GDPR won't apply to it. But I would really sort of test that theory with somebody within the business to see if having access to everything that they have access to, whether they could figure out who that data related to, and if they can, well then it's clearly not anonymous data.
Okay. Hopefully that's clarified that, and that's been helpful. So those are all of the questions, unless anyone wants to send any more through really quickly. We're almost at the end of the hour slot as well, so I'll just skip on to the, just checking no more questions. Oh, hang on, one more question. Any tips on guerrilla research? So anything unique? So that's where you would, if my understanding is if my understanding is correct of guerrilla research, that's essentially where you might go out into the street, into a public space, or a coffee shop to try and approach people. So imagine you're doing research on behalf of Starbucks and want to understand user behaviour around choosing which coffee mug they want to purchase. You might stand there and talk to people as they're making that choice.
That seems dangerous to me.
Okay.
I think that first of all, you have to consider whether the proprietor of the establishment would be happy with you coming in and conducting a business activity essentially on their premises. But let's say, for the sake of argument, they're really chilled out about it. You're sort of apprehending somebody in a private context, really. Just because they're in a public place doesn't mean that they're not in the private sphere enjoying their coffee or their beer or whatever it might be. If you ask them if they want to participate and you present them with a consent form and they're made to feel very awkward about that, then query whether that consent would be validly given. Query also whether you're going to, the quality of the data you're going to obtain in that context is really going to be any good or of any use. I think it's, and I'm speaking as an industry outsider here, I have to say, but it seems to me at least that you're more likely to get the best results from somebody who had a reasonable expectation that they're going to be approached to participate in research, rather than somebody who's kind of setting about their daily business and kind of apprehended on the spot and sort of asked to do that. So I think that it's as much a kind of a commercial question or a best practice question rather than a legal one.
Okay.
But if you are going to ask for their consent to process their personal data, I would query how watertight that consent can be in that context.
Okay. So potentially they might have felt, I should say yes because it feels awkward saying no.
Yeah, I think so.
Okay. So just going back to the last couple of slides, we've got a couple of useful links here. So the Information Commissioner's Office is really the first place I would recommend going to for information. It breaks down the regulation into easy to read sections. We've got a bit of information on our blog. We did a couple of blog posts earlier in the year about GDPR, so just drop us a message via Twitter or any other means if you want specific links to anything. I've got a link to the workshop Kate Towsey did, the information page about that, and Greg Latcham's website. So again, thank you very much to Ed Boll for coming along. If you want to get more specific legal advice, please do contact him via Greg Latcham's. And thanks so much for everyone who's joined us today.